I think you were both on, Robert and Shelley, you were both on last week, right?
Yes.
I was not here last week.
Oh, you weren't? All right. So we'll give a little summary. And then we'll see. Shelley, you want to try to summarize? Do you feel confident?
No.
All right. It's worth a shot. All right. So just in terms of the Parsha, the contrast. So last week was Shoftim, and this week is Kitetse. And the main contrast between the two is that Shoftim deals with leaders and boundaries. So, for instance, with kings, it says, yes, you can have kings, but they shouldn't accumulate wealth. They shouldn't accumulate wives. Basically, the message being that they shouldn't be like other kings that are, all about power. They should be more about being representatives and carrying out God's will. They have to have their own Torah. And the rabbi said actually they had two Torahs. One was, stayed at home and one they traveled with. And there's laws about prophets and all kinds of, but it's really about the leadership. In our Parsha this week, in this week's Parsha, Kitetse, the focus is much more on the individuals. It's about, marriage, it's about the home, it's about sexual relations, but it's very much about the individual. And last week, we started working through a document by Rabbi Elliot Dorff, who's one of the leading voices in the conservative movement, titled Judaism as a Religious Legal System. And kind of comparing halacha, Jewish law, to the American legal system and in general to other legal systems. And, how much they're the same, how much they're different, what basis does halacha have, how much malleability, how flexible is it, right? We know that there's certain laws that are explicit in the Torah, including in our Parsha, where we have arguably the most disturbing law, if not the second most disturbing law, which is the wayward son. The only one I can think of more disturbing is the one we talked about a couple of weeks ago, which is the irredeemable city. But basically, we're commanded to kill people. People that are idol worshippers, or with the wayward son, it interestingly doesn't even mention idol worship, if I remember correctly, but it talks about him being a glutton and a drunk. I could think of a lot of people I know who would end up dead if that was the standard we used to off people. So the rabbis basically legislated these things as well as other mitzvot out of the possibility of being executed literally in terms of killing them, as well as basically these commandments. They said, maybe God can handle it, but we can't. Interestingly, I saw it pointed out that the context of when the rabbis did that happened to be when the Romans took capital punishment away from them anyway. So even if they wanted to execute, they weren't able to. And so there's an argument to say that they rationalized their loss of power by making it impossible to do. And they created all kinds of obstacles to ever being able to carry out capital punishment, including needing to warn the person immediately before they do the action, not just warning them, but warning them and telling them that it's a capital offense. There needed to be 2 witnesses. Those witnesses couldn't be related. They just put more and more obstacles in the way. The point of that being to say that Jewish law, the way it's reflected in rabbinic literature, is in many ways is different to if you do a literal read of the Bible, right? We don't do an eye for an eye. There's a whole bunch of things, as well as some things which can be considered loopholes or however one sees them, as well as a lot of interpretation, right? So when it says you shouldn't cook a goat in its mother's milk, it ends up being, don't have a cheeseburger. So, how they get the authority to say that and all of that is also included. And this is something that Shelley had kind of pointed out. One of the things that he mentions is that, to understand Jewish law, we need to understand that Judaism is not just a religion in the common understanding of religion, but it's much broader. So there are laws that normally would have nothing to do with religion that would be completely secular, such as contracts. If I'm buying your field, what does that have to do with God? What does that have to do with, praying? But yet there's laws about it, and that's depending on your perspective. Either it's there because we also are a nation, or the term that Rabbi Mordechai Kaplan used, a civilization. While others say that because it's a divine law, God looks at the whole picture. Anyway, we're going to continue from where we left off last week. And if anybody has any questions or comments, just jump in. So I think this is as far as we got to, because I wrote continue from here. So how is it possible? Okay, so he's continuing from the rationale, and this is the way I was taught growing up in an ultra-Orthodox environment, that everything that it says it in here, so I'm just going to go with it. How is it possible that everything that was revealed at Sinai, and yet new things are revealed each day, right? We were taught that everything, including even, a debate of rabbis today, was already given to Moses at Sinai. It seems like a lot to cover in 40 days on a mountaintop. Actually, the situation is not as contradictory as it may seem, as those trained in the law, meaning lawyers, will readily recognize. On the one hand, with the exception of the last 16 amendments, the Constitution of the United States is the same as it was in 1791, when the Bill of Rights was ratified. Its meaning, however, has been extended far beyond the probable intention of its framers, because judges and lawyers and scholars have carefully examined its every phrase in applying it to new problems and circumstances. Right, so the words are the same, but the understanding of it continues to evolve. Its meaning has changed a number of times when the Supreme Court has reversed itself or greatly narrowed the application of previous rulings. In an important sense, all of the later developments were inherent in the original Constitution because they are all derived from the governmental body that it created. So just to read that again. And this is one I don't completely buy into, but this is an argument to try to explain that for those that believe that it's not literally that Moses actually heard every, theoretical argument. It's saying that it was more principled, but it derives from it, and so you can still make that claim. All of the latter developments were inherent in the original Constitution because they all are derived from the governmental bodies that it created and the general principles that it established. The Constitution is understood and applied in many novel ways each year, or in more theological terms, many new previously undiscovered meanings and applications are revealed over time. All of the new meanings, however, are dependent upon the Constitution, which originally set up the structure for those interpretations and applications. Right? So some people believe that it was actually Moses, he was a super fast learner and he was able to learn everything until the end of days, whenever that is. And others believe that it was much broader, but it incorporated it. A similar analysis can be applied to Jewish law. On the one hand, every interpretation and application of Jewish law that has ever been, is, or will be made already was revealed at Sinai. They were revealed at Sinai because every one of them comes directly or indirectly from the procedures and principles embodied in the Jewish Constitution, also known as the Torah. Right, and over here we're talking about the written Torah. Even revisions that rabbis have made over the centuries are based upon the authority the Torah gives the judges to act on behalf of Jewish law in every generation. The revisions may represent a change in the content of the law, but they are nevertheless part of Jewish law because they were enacted by its study and authority where am I? The revisions may represent a change in the content of the law, but are nevertheless part of Jewish law because they were enacted by its duly authorized representatives, right? So one of the key problems that the rabbis had is that in one place it says, and I think we covered this last week, in one place it says, more than one place, it says, do not change anything. Don't add to it, don't subtract, this is it. This is the law, gendigt. Right? But in other places, it talks about when you're not sure, you go to the authorities at the time to get clarity. And, if they don't know, they can bring it, in temple times, they can bring it to there was the Urim Vitumim, I forget the English word for it, but this special place in the temple between the two seraphim that you can, that God would channel the answer. So the rabbis take their authority from that because they're the authority now, and so in new situations they can add. But they're saying they're not really adding, they're adding based on what's already there. Similarly, and more importantly, each time a Jewish court or judge decided to interpret the Torah or Talmud in one way and not another, the meaning of those texts changed. The meanings of those texts changed, right? So this is that idea of the dialectical, right? The idea of going back retroactively and sort of changing something, right? We can't change the past, but we can change the meaning or discover the meaning of the past where what we thought the past was is now different. Through this process of interpretation or midrash, the texts sometimes were given meanings they never before had. Sometimes, however, several possible alternative lines of interpretation were cut off by this process. In any case, whether a given verse in the Torah was being expanded or contracted in meaning or application, this process was possible only because the Torah established the ground rules and procedures of Jewish law. On the other hand, in every generation, the Torah is given new meaning and applications, and in that sense, quote, matters that had not been revealed to Moses were revealed to Rabbi Akiva and his colleagues. I guess that's an end quote there. Meaning that there's new revelation, but in this case, the revelation is not where God is literally speaking into somebody's ear word for word, but by their being engaged with it, they see it. The authority of Jewish law does not diminish, then, as it is applied anew in every generation. It must be so interpreted and applied if it is to continue to live, and the rabbis clearly recognize this fact. Is everybody with me so far? I know some people jumped on. Go ahead.
Yeah, it's Shelley. I just want to say what I learned in the yeshiva, in fact, what I learned in Young Israel, is not this, as you said in the beginning, and I just wanted to be clear about that. That is, what I learned is that each and every discussion in the Talmud was revealed to Moses on Mount Sinai.
Right. Right. And so the problem with that belief is that, you know, if the point of the Torah, as Rashi seems to indicate in the first Rashi in the Torah, is that it's primarily a law book, right? It also has the history. It also has, prose and all of that, but it's primarily a law book. Then why would Moses be given all the different arguments? You know, Shammai says it's permitted, Hillel says it's not permitted, the third guy says, well, it depends if it was talking about this or that. Moses should have been told, this is permitted, this is not permitted, and the guy who says it's not permitted is wrong, right? But we have a lot of discussion. And then the question comes down to belief. What do we actually believe happened? How much revelation do we believe happened? And of course, the question that follows that is, and therefore, how much authority does it have over our lives and our actions? But generally, that was the belief, the authority the rabbis had. If we believe that everything that they discuss and ultimately the conclusions that don't come from them alone, but actually come from God, it has much more authority. So far, the importance of interpretation has been seen in what the rabbis said. This importance is even more evident, however, in what the rabbis did. By using the method of exegesis that they had developed, the rabbis totally annulled some biblical laws and created new ones. An example is their treatment of capital punishment, as I was talking about before. The Bible requires capital punishment for a whole variety of offenses. The rabbis, however, created procedures for capital cases similar to the practice in American law of advising an accused of his constitutional rights. Right? I mean, if I see somebody, if somebody tells me they did something wrong, then, you know, who cares about somebody, whether the person knew their constitutional rights or not? They told me they did something wrong. They should be punished for it. They admitted it. But we put limitations because people can be tricked or whatever. And the same thing is true with the rabbis. They put limitations. These procedures were so demanding, it became virtually impossible to obtain a capital conviction under Jewish law. One of the procedures they instituted required that the culprit be warned by two witnesses immediately, and when we say immediately, some say within 3 seconds, immediately before committing the act, that it was unlawful and carried the death penalty. The reason for this procedure was that the wrongdoer might not have known that the act was illegal or would be punished so severely, and therefore he could not be put to death for transgressing the law, transgressing a law of which he was unaware. So that's the rationale. Another requirement was that the accused respond, even so, I'm going to do it, right? So that there's, in medicine now, they call it the talk back method. Because people realize that just because a doctor or a nurse or somebody says something to a patient doesn't mean that they actually heard what you think they heard. And it's true in communication in general, where you ask somebody, can you paraphrase back to me what I said? Obviously in a respectful way, to make sure that they really understood it. So the witness might think, oh, I warned him. I told him it has the death penalty. But the other person may have heard something completely different. And so according to this, he has to confirm that he actually knew what it was. Although it's not a complete paraphrase, but he has to confirm at least that he heard it. This response would assure that the warning had been heard. Still, another requirement was that the act be committed within 3 seconds after the warning was heard. Otherwise, the law might have been forgotten, and therefore the accused could not be held responsible. Finally, the witnesses must not have been related to each other or to the culprit, and at least one judge on the court must have voted to acquit. This is a fascinating law I've talked about in the past. If it's unanimous, you can't kill him. The reason for the vote of acquittal was to show that the court was not prejudiced against the accused. Right? I mean, it's fascinating because you'd think if it's a slam dunk case, everybody would just say, it meets all the requirements. Why would you need one person to acquit? But they were so concerned about, with capital punishment, there's no going back. If you find later that you made a mistake, it's too late. Interestingly, I was reading in Israel, there were only the modern state of Israel, there were only 2 cases of capital punishment. There was Eichmann, and then there was a soldier, I think a general maybe even, in the early days of the state that they believed was a traitor. And they felt like they had to execute him because it threatened the very existence of the state. And so they killed the guy, and then they found evidence later that they were wrong and dug him up, put him in a military cemetery, and said, oopsie. And so that's just one example. And, you hear these stories all the time, especially now with DNA evidence, where somebody is exonerated, but it's too late because you already killed them. Some of the requirements, as the rabbis certainly knew, are implausible extensions of principles that are reasonable in a different form. Right? They took things which in other cases would make sense, but in this case are really extreme, but they took them anyway. They felt they had the right to do it. The rabbis, however, had decided to outlaw the death penalty despite the numerous times the Bible required it, and they used the procedures to accomplish their purpose. Thus, the rabbis interpreted the death penalty out of existence. The rabbis of the Talmud clearly and consciously changed law, adding a number of laws, dropping some, and changing the forms of others. They did not take their responsibility lightly, but they modified the law in many of the same ways that the lawyers and judges of non-religious legal systems do. Or, for that matter, Congress, right? I mean, the judges and lawyers are not supposed to be the ones making laws, but they do make precedent, which in a way makes laws. Thus, the methodology used by the rabbis resembled that of judges and legislators in non-religious legal systems. So far, this article has discussed the Jewish and the secular law, as those systems are found in the writings of the rabbis, lawyers, and judges. In both Jewish and secular law, however, many decisions are not made by the officials of the legal system, but rather are determined by the customs of the people, tradition. Judges and lawyers of any legal system may not be completely comfortable with customary practices, and they may resent the fact that the scope of their own authority is diminished when decisions are made by reference to customs. Nevertheless, the law always is determined by both the officials designated to make such decisions and the customs of the people who agree to accept their authority. And there's numerous examples of that, which I think he's going to bring some, if not I can. This symbiosis has important methodological consequences for both Jewish and secular law, because it means that law and custom must be adjusted to each other periodically. This adjustment takes many forms and extends in both directions. Right, so a great example of this that comes up often is polygamy. Right, in this week's Parsha, we talk about the treatment of a second wife or of a captive wife, or the child of the wife that the person likes less. Clearly, there's no explicit prohibition against polygamy. Okay, the king shouldn't have too many wives, you know. But the rabbis outlawed it, arguably because it had become seen as morally wrong in a lot of the societies that they lived in. So that's where custom would affect law. To see how law and custom adjust to one another, a distinction must be drawn between custom and usage. The term usage describes the common practice of the people. On the other hand, the term custom describes rules that have evolved from common usage. So after usage for a while, it becomes a custom. Because those rules are often enforced, they may exert the same authority as laws or judicial decisions. Therefore, usage is a purely descriptive term, while custom is partly prescriptive. So again, what we're talking about here is the interchange of custom and law and how they affect each other. When law and custom interact, law is sometimes the active partner. If a law or a precedent exists, there is no need for the added authority of a custom. But laws and judicial decisions sometimes do affect custom and thereby establish usages. For example, some but not all states allow motorists to turn right on a red light. Not New York State, clear. Well, actually, not New York City. Recently, New Jersey, when we say recently, this is a very old article. New Jersey, Wisconsin, and other states have enacted legislation permitting such turns and have thereby created a new driving practice in those states. So I think what he's saying is that it was allowed but never actually written into the law. Kind of the example that I can think of is alternate side parking. I don't know how true this is in Staten Island, but in Brooklyn and Manhattan, probably, you know, the other four boroughs. So for example, on my block, when it comes to alternate side parking, people double park on the other side, and they don't get tickets. The meter maid or whatever, the traffic police, whatever you want to call them, come around. If you're on the alternate side parking side, they'll give you a ticket. If you're double parked on the other side, which is just as illegal, they will not give you a ticket. It's custom. It's not written into the law, but it's become so common that I feel confident that I can go into the house, do what I need to do, as long as I get back quickly enough before the other cars don't come run and take all the spots. And I've done it and never gotten a ticket for it. I don't know if it's true in all blocks or all neighborhoods or boroughs, but I've seen it in Brooklyn and Manhattan. So that's a case where the custom is kind of becomes the default, which is basically like the law. Conversely, laws and judicial decisions can function to abrogate both usage and customs. So, for example, the Supreme Court's integration decisions have uprooted long-standing usages and customs in many areas of the United States, in addition to overturning a variety of laws and decisions. Thus, it no longer is common usage among advertisers to picture white people exclusively. And the unwritten rules, customs prohibiting friendship between blacks and whites also have been set aside, right? And so the custom in a lot of places was that segregation was perfectly okay. And it took the Supreme Court to basically outlaw a lot of the practices of segregation. And it affected custom. Influence may be exerted in the opposite direction. Custom may define the nature and authority of the law. The most prevalent and hence the most important examples are the numerous laws that codify long-standing customs, or that simply refer to custom. In such cases, the law must be adjusted to custom rather than custom to the law. More dramatic illustrations of how custom defines the law occur when custom effectively annuls laws by making them unenforceable. The most famous example in American law is prohibition, right? So the law was very clear, no alcohol, but there were speakeasies, people were making gin in their bathtubs, when even a constitutional amendment could not change social practice. Ultimately, they realized it's not happening, we might as well just change the law. And prohibition is gone. Thus, law can establish usage and custom. Thus, law can establish usages and customs can produce law or operate in its place. Law also can uproot customs and customs can nullify laws. The same interaction between law and custom occurs in Jewish law. The law determines custom when there are no previously existing convention or when practices exist that officials find objectionable. As in American law, when Jewish law determines custom in the absence of convention, rarely is it considered an interaction between law and convention. If there is no convention, then it's not you just think of it as people are following the law. They're not following a custom because it's the law, and a law seems like a higher thing than a custom. It nevertheless is such an interaction because the practices of the members of a society are inevitably influenced by that for which they can be held accountable in court. Right? So the actions of people following the law is a custom as well, right? Because there are laws that the custom is not to follow. For example, the speed limit. Most people are whether it's 2 miles per hour over or 20, on most highways that I've been on, are clearly not following the law. The custom is to not listen to it. For example, Talmudic legislation concerning marriage had a significant influence upon common practice. For one thing, it transformed the bride price from a sum that the groom had to pay at the time of marriage into a lien against his property in the event of divorce or his death. Right? So it used to be, if you want to get married, you have to pay a certain amount, right, straight up front. Now we have a ketubah that says, that puts all kinds of conditions on that some things during the marriage and then other things if you leave. This change, but you don't actually have to pay anything up front to get married. This change encouraged marriage by removing the economic barrier and at the same time change the assumptions and rules of governing a man's ability to divorce his wife. So it made marriage easier, and it made divorce a little costlier, which works to maintain marriage. The influence of law on custom is more apparent when a law abrogates a custom. right? Before it talked about cases where there is no custom, and so making a law doesn't seem like it has anything to do with custom. But sometimes it clearly eliminates the custom. Menachem alone lists 4 situations in which the law, as interpreted by the rabbis, had this effect. When the customs were founded on an erroneous understanding of the law, right? So if enough people misunderstand the law and a custom evolves, but the rabbis say, you know what? This is completely based on a completely wrong understanding. And so even though it's a custom, we can't let it ride. Second, when the customs were deemed unreasonable because they imposed undue hardship on others, or were deemed illogical because they acted contrary to the purposes of the actual law, right? So sometimes there's a custom that benefits, just a few wealthy people or a few, kohanim or whatever it is. But it actually hurts most people, or it's just completely irrational and it just evolved and nobody knows where it came from. But usually, unless it's harmful, they're not going to bother with it. 3, when the customs were bad, they were just perceived as bad, which is not completely clear what he means by that. 4, when the customs were contrary to fundamental rules of Jewish law. So even if there wasn't a direct misunderstanding, but it goes against the general principles of the law. The ability of the law to abrogate customs and usage has varied according to the power and the prestige the rabbis have enjoyed in various times and places. Right, and there's been a wide range of that. Sometimes they had full authority, sometimes they didn't have much. For example, modern rabbis are having a difficult time convincing Jews to observe the dietary laws, even though failures to do so is a clear violation of Jewish constitutional law. Whether successful or not, however, rabbis have acted in opposition to accepting usage and customs, and alone provides many examples of such action in all 4 categories. The most important interaction between law and custom, if only because it is often ignored, is the way in which custom influences Jewish law. Right, and this is again the Tevye tradition, right, where we give much more influence to tradition. I remember learning this and thinking to myself, this doesn't make sense. Like, why would we care if the law is coming from God? If it's and God's laws are just and right and good, then who cares about tradition? God knows better than people. But it's not that simple. This influence occurs most often when custom functions in the absence of law. The Jerusalem Talmud specifically recognizes this function when it discusses whether it is necessary to set aside tithes from fruit trees in their 4th year. Right, we're supposed to bring, in the 3rd year, we're supposed to bring the first fruits. There's different tithes that apply, but there's nothing about the 4th year. When there is no clearly established law on any matter before the court, and you do not know what its true nature is, this is what the Jerusalem Talmud is saying, go and ascertain the custom of the people and act accordingly. And we see that the public does not set aside tithes in this case. Right, so there's no precedent, so then custom kicks in to become law. Later Jewish law codes applied this principle broadly, often by simply recording the common practice. Consequently, customs govern much of Jewish civil and ritual practice. And, a great example of this, of course, is the Kol Nidre, which, you've all heard rabbis over the years talking about it, that there's been a lot of ambivalence over the years about how, whether we should do it or how it should be said. Are we annulling, the previous promises or future promises? There's certainly no place in the written Torah that says anything about doing a Kol Nidre on Yom Kippur. But it became the custom, and the rabbis, for those rabbis that were uncomfortable with it, they acquiesced, basically.
Rabbi, can I ask you a question? It's Jack.
Yes.
I'm looking at all the clothing that the Hasidic wear, which is basically a 16th century or maybe 17th century custom.
Yeah.
And yet, if they don't wear it, I don't think they can they can be part of the sect. Maybe I'm wrong on that. I'm not sure, but how does that work? Is there a law? Is that just, I know it's just custom, but it seems to be going on for centuries. And is there any writing about that?
There's a lot of writing about it, in terms of more from a sociological perspective than a halachic perspective, right? So there's no halacha to wear a fur beaver hat. There's no halacha to wear a fedora with the brim down, or to wear white socks up to your knee. But as Jack, rightly points out, I don't know that they'll say that you're not a chassid, but you're certainly going to be, if not ostracized, looked at as strange and suspect, right? Because those norms and customs have become, they've taken on not just that this is our sort of uniform, but they've also kind of taken on a ritual element to them, and almost a holiness, as if this is part of worshiping God. When they originally, that style happened to come out, it might have been seen as, by some people who had a different fashion that they thought was appropriate for a pious Jew to wear, as modern and wrong. But it is a great example of custom becoming quasi-law within those groups. Yeah. Right, but it's a subgroup. It's not because they don't expect the other group, like the Satmar don't expect the bells, or the bells don't expect the Skver, or the many different groups to wear that exact uniform. But they do generally expect them to wear their own version of that uniform. Yeah, it's fascinating stuff.
All right, thank you.
Yep. Later Jewish law codes applied, we said that. So they apply the principle that where there's no law, that custom prevails. Some authorities claim that customs are merely laws that were enacted long ago, but are no longer recognized as such. Right? This is a little bit of a stretch, in my opinion. This view gives custom latent judicial authority. So basically, it was a law, but we forgot it. But the custom shows that it was a law. Others claim that the authority is divine, as in the famous statement of Hillel the Elder, when asked to rule on a question concerning the Paschal sacrifice. He said, "Leave it to Israel. If they are not prophets, they are still the children of prophets." Meaning that they kind of know what God's will is, and thus it's divine. Most scholars claim that customs are authoritative in secular matters because Jewish law permits the parties to a transaction to agree to their own conditions. Jewish law thus defers to custom in those areas with the effect of making the custom the law. This particular statement is really important when it comes to the aguna issue, which I've talked about before. The aguna, or in English known as the chained women, are women whose husbands refuse to give them a get. And because traditional Jewish law requires that the husband give the get willingly. If he doesn't give it, then the woman, assuming she's observant enough and cares, cannot remarry. And it's a huge problem because there have been men, and there still are men, who use it as a bargaining tool in their divorces to get what they want. And so rabbis have struggled over the years to find a way to basically legislate that manipulation out. In the conservative movement, the Lieberman clause is the way we do it. In the modern Orthodox world now, there's something called a halachic prenup. But in the ultra-Orthodox, and according to my father, my great-grandfather, his father's father, was extremely against the Lieberman clause. And of course, it's always the argument of the slippery slope. And if you make this change, then what's to say people are not going to change? The next thing, then there's not going to be anything left.
This is Shelley. I just wanted to make one comment. Typically of the Talmud, we went a couple of months in Pesachim dealing with the question of, okay, there's a custom in one place and a custom in another place. The customs differ, and you travel from one place to another. Now what do you do?
Exactly. This paper is written on a global scale, but Judaism in reality is much more complex because of that exact thing. And I remember growing up, there was something that I found really fascinating, which was, the Chabad movement is kind of it's not just a live and let live. It's a live and encourage others to live like we live.
Right.
And so every so often, you'd have somebody who was from a different, whether Satmar or whether, a Yemenite Jew or something that would decide that they wanted to follow that way of life. But for instance, if they had a certain look, from a different Hasidic sect, or they had like long payas or something like that, the Lubavitcher Rebbe was reluctant. It would encourage them to keep it. Right? So in every other way, it's, hey, come join us and see the world and practice, Judaism the way we do it. But with that look, it had such, the custom was so strong that he didn't want to mess with it. But yeah, it does become much more tricky with customs being different around the world. And interestingly, today, as the world gets smaller, because we know what's happening across the world in seconds.
Rabbi, I'm sorry. I was just thinking of Passover, where Sephardic will eat rice, I think, and we don't, and I'm sure there are other groups. And yet rice, if it was brought into Spain, was a much later food product. I mean, from what I remember, it really wasn't in that part of the world for quite a long time. So, and yet it's their thing. We don't. And it's a complication. In the army, we had Jews from Tunisia, and they served rice for Passover. And it was just tricky. I mean, we ate it, but it was just a little weird.
Well, and you would think, for the non-Jew working in the kitchen, he's like, all right, I'm making I have to go and get Jewish food. And then you tell him, well, actually, there's this kind of Jewish food and that kind of Jewish food. It gets really tricky. And, and the thing that you guys know and a lot of you practice is the conservative movement officially came out and said, that custom just doesn't make sense anymore in modern times. It's okay for Ashkenazim to eat rice and kidney. And yet most people that I know in our congregation, their custom is so strong that they don't feel comfortable with that. And so even though, we're members of United Synagogue, we're officially following that leadership, but the custom in a lot of cases is stronger. And so I'm distracted by Zahava making funny noises right now. It's okay. Yeah, so that's another great example. All right. Customs also serve to decide what the law is when the legal authorities differ. When customs act in this way, and again, this is global because, the way he's presenting this is as if there's only two positions on a given thing. One says yes, one says not. And in many cases, it's more complicated than that. They might differ in this situation, but not in that situation. And the them might be multiple thems. When customs act in this way, however, they are in effect acting in the absence of law, because in some areas of Jewish law, when the jurists disagree, there effectively is no law, right? Because if they're the ones making the law and there's no agreement, then there's no law. This situation does not arise in American law because there are definite methods for reconciling such disputes. Well, I think it does exist, but it can be resolved. But such methods have not existed in many periods of Jewish history. Both the Babylonian and Jerusalem Talmud record instances when conflicts between laws were settled by the rule, quote, go check the practice of the people, end quote. In post-Talmudic times, most rabbis followed the rule that in disputes about biblical law, the more stringent view was to be followed, but that if the dispute concerned rabbinical legislation, the more lenient rule prevailed. That rule, however, was set aside when there existed a clear customary pattern to the contrary. All right. As Rabbi Meir of Rottenburg stated in the 13th century, in all matters on which the great legal scholars are in dispute, I hold that a stringent approach must be followed, except when the permissibility of a matter has spread in accordance with the custom of the scholars by whom we have been preceded. Besides helping to define the law, customs often serve as the source of law. The rabbis have even claimed that custom always precedes the law. The validity of this statement is doubtful, but it is certainly true that many rabbinic and even many biblical laws had their origins in the customs of the people. Laws such as those requiring circumcision or prohibiting the eating of blood may well have originated in patriarchal days, as the biblical records before the formalization of Jewish practice in a legal code, right? I would argue even before that, we adopted laws that existed, even before the patriarchs. Many of this, as we see in the Hammurabi Code and things like that, that these similarities, it's certainly possible that these things were already in place. Many of the stories in Genesis assume rules of custom that are only later given legal articulation. For instance, the story of Judah and Tamar revolves around the laws of Levirate marriage, which first only appear in chapter 25 of Deuteronomy. Of all the instances in which custom affects law, those in which, does everybody know what Levirate marriage is, by the way? Anybody want me to explain that?
Yeah, explain.
So that's where a couple is married, they don't have any children, and then the husband dies. And so there's a responsibility. In the Torah, it's written as the next brother has the responsibility, but in the story of Ruth, it extends to the next kinsman. Has a responsibility to marry that woman and to have a child with them, and that sort of continues the legacy of.
They can't just give her the property. She can't take care of herself.
Did you guys hear Dora on that one?
No.
She said, because they can't just give it to her. Right? I mean, it's clearly a men-centered law. So they have, for his lineage to continue, the brother has to, give a child, or the kinsperson. But the first mention we have of this as a law is only at the end of the 5 books of Moses, even though there's a story that includes that earlier. Of all the instances in which custom affects law, oh wow, we're going pretty late here. I didn't realize. All right, jump. I mean, you get the general gist of this. Law affects custom. Custom affects law. Jewish law is in many ways the same as secular law. The key difference is how much authority it gets from God. For those that believe that everything in it is completely from God, that's not even a question. It has absolute authority. There's no questioning. There's no discussion. End of debate. For those that believe that it has some authority, for instance, through principles, well, then there's some wiggle room, but how much and by whom? And then for those that believe that it has no divine authority, the question becomes, is there any value in it? And what he talks about is, for even those, the mitzvot work as a framework for spirituality, right? The popular spirituality now is, meditation and, sort of feeling connected and feeling, but it's very much coming from me going out. Versus Jewish law says, the expression, take the actions and the feelings will follow. Or,
Soviet forces are poised to assault
the
Allies have smashed the Nazi armies
fake it till you make it. Or, basically the idea that by doing the actions, the thoughts and feelings come. So if we believe that these are moral and good actions, then by doing them, that helps shape us, and ultimately our happiness, our community, and the world, so that we can make the world a better place and we can be happy. So that's a summary of the rest of it. Any questions? All right, so I'm going to hopefully remember to post the link to the actual article. And then I found another one, which I just want to hear if you guys are interested in me doing, which I thought was pretty interesting. If only I could find it. Right, no, hold on. I don't have it handy right now. All right, I'll see for next time. But it was basically the conservative movement document. Yeah, I'll see what where we go with it. But I just thought it would be good to kind of see where the conservative movement stands and some of the thought process, because that's kind of where the synagogue is.
Just Rabbi, in doing a presentation of the conservative movement, is it possible to compare and contrast too?
Absolutely, and I'm happy to do that. And I think that's really important because that helps us understand. If we can't compare and contrast, then we miss the point of the conservative movement, which was to say certain things are so important and essential that they need to be preserved. And even if it goes against the modern prevailing culture and custom.
And his wife even killed their 6 children before taking their own lives.
Just don't make sense in today's day and age and are not worth preserving. And are not,
From their foundation,
so essential
the Nazis always said
that they would alter
the
the basics of Judaism. All right, guys.
It was always a fundamentally flawed
I'll see you on Monday, hopefully, or Thursday.
All it has led to is destruction.